Hi, I'm Brian Heidelberger, a partner with the law firm of Winston and Strawn in Chicago, and I'm here today with your Advertising Age mini law lesson. Today's law lesson, how to respond to a cease and desist, which makes my standard disclaimer extremely important because while I can demystify the process and maybe teach you a thing or two, I certainly can't stop somebody from suing you. Rule number one, do not freak out. It is going to be okay if you receive a cease and desist. And why? Well, because in truth, a lot of people send cease and desist, but not nearly as many people actually sue over them. There's a long road from receiving a cease and desist to getting a lawsuit, and we don't necessarily end up in court just because we get one of those cease and desists. What's the first thing that we do when we get a cease and desist? Let's get organized. And what do I mean by that? I mean, get all your documentation together, all the correspondence on this issue. Check your insurance. See what your deductible is. Put your insurance company on notice if this truly looks serious. And then talk to a lawyer, one that's experienced in advertising, marketing, promotions, privacy, copyright, trademark, whatever the issue is that's being complained of. You want somebody who's seen it many times and knows what's serious and what is not. In that regard, let's determine how serious is this letter. Like I said, not every cease and desist is super serious. You need to look first at who is sending it. When it's your competitor, they've got many different motives, and not always is it going to court. A celebrity, on the other hand, has one motive, and that's to stop you from running the advertising and from obtaining a licensing fee from you. So that one's probably a little bit more serious. Now, the FTC and state attorney generals, they don't send letters unless they are very serious. However, sometimes the state attorney general forwards you a consumer complaint. That is not them coming after you, and not nearly as serious as if it's the FTC or the AG actually bringing the action themselves. Class action attorneys, they certainly send letters, and when you receive them, they don't always bring a lawsuit, but many times they do. So you want to take those pretty serious as well. Once you've determined how serious they are, you also want to look at their motivation. Are they just looking to put you on notice or to scare you? Or are they just taking a shot at getting some money from a deep pocket and really don't have the gumption to bring a lawsuit against you? Or are they somebody who really needs to stop your advertising from running, or somebody who usually sues and does secure damages? You want to look at all of those things before determining whether this is something that you really need to be worried about. Now, in terms of whether you should be worried, let's look at the potential for damages. What are the damages that could be brought? There are monetary penalties that could be brought. You can be fined anywhere from $25 to over $1 million for the FTC or state attorney generals. Sometimes they can make you give consumers restitution for every widget that's bought. They can make you send back the value of that widget. If a company has been damaged by your actions, that could be anywhere from $10, $100, $1,000 to $1 million, and that's something that a company could seek from you, as well as profits. Now, they could seek the profits that they have lost by your actions, but also the profits you have earned by their actions in certain circumstances. So you want to think about that as well. There's other things like a consent order that can be entered into. So as you see here, it's not always about just pulling the advertising, which is often what we as marketers think is the worst thing that can happen. It can get a lot worse. And regardless, you've got legal fees, you've got a huge waste of time and money, so you do want to try to avoid getting these cease and desists at all costs. Now, what are the potential business implications? That's the next question you want to ask. And you need to look at, how long does the campaign have left to run? Is this something that you can stop, or can you really not stop? You want to look at things like, how upset is your client going to be if you're an agency? How much does it cost to change? All of those things are critical in determining the business implications. You also want to look at your deductible. If it's $700,000, you'll be paying all $700,000 until the insurance company starts paying for you. So you want to determine what deductible works best for you. Maybe a smaller deductible works best for you. Now, obviously, that means higher rates, but then when you do have a claim, you're going to have less out of pocket. So the next thing to determine is who's ultimately responsible, who should be responding on this cease and desist. It might be you as the company, it might be the advertising agency, or some third-party subcontractor or licensor or production company. But we need to look back at your contracts to look and see who took ultimate responsibility, and that's why it's important to have those contracts vetted up front. When you determine how to respond, there's a variety of ways. You see them here. And everything is a unique and different situation, and sometimes it's a combination of each of these situations. And you need somebody who's experienced, who kind of can feel which is the right way to act in these circumstances. And you need to realize that, listen, lawyers are good, I'm a good lawyer, but I can't stop every lawsuit from occurring. Sometimes there's crazy people that are going to make you spend a lot of money on litigation even though you did nothing wrong. So we want to be prepared up front, and that's why you have all your contracts reviewed up front, and make sure that you shift liability where you can. You want to make sure you have that insurance coverage and your deductible works right, and you want to make sure that risk decisions are being elevated to the right person at your company. Don't let the junior people take risks on behalf of your company. Make sure that the people who have a vested interest and who are going to be there for the long term are deciding whether to take that risk and whether not to. Now, step 9, be happy. There are only 9 steps in my 10-point plan, so let's cross our fingers and hold our breath. Never speak of again if we get a cease and desist after we send that response letter, and see what happens from there. So I hope you enjoyed it. Oh, come on now, it really wasn't that bad. Don't forget, next time, we'll see you soon. In the meantime, let's be careful out there.